He was fired before it was officially reported, and the company's blame-shifting behavior was baffling. Fired before working, Alice, a junior high student, got an email to report on September 22nd, but was dismissed on September 2nd due to a lack of empathy. The email acknowledged a mistake, yet HR claimed the contract date was September 2nd. Who's at fault? Don't forget to subscribe, retweet, and like before we dive in. One, the incident review email says the 22nd, and the contract says the 2nd. The client received the employment confirmation email, passed the background check, and the entry date was September 22nd. Before the 22nd, the company suddenly sent a dismissal email saying that he didn't arrive on the first day of September 2nd, and the employment relationship was terminated from September 2nd. HR later admitted that the date in the email was indeed wrong, but added that the contract you signed was September 2nd. The client shared two conflicting emails. When selling coal fryers, who should prevail? What's wrong is why do companies punish employees? It has also been reminded that the conflict between email and contract and employees should confirm the key points twice. The conflict between email and contract is the core of the whole dispute. In reality, the offer letter of many American companies is not a labor contract, but more like a disclaimer of confirmation of employment points and repayment as well. Labor contracts in the true strict sense are rare. 2. Legal background. The boundary between arbitrary employment and revocation of employment. 1. Arbitrary employment. In most cases, the employment relationship is arbitrary employment, and the employer or employee can terminate employment at any time and for almost any reason, as long as it is not illegal discrimination or retaliation. Therefore, it is not impossible to be fired without reporting it at the rule level. 2. The offer is not an iron contract. In the United States, most new employees sign an offer later, rather than an informal employment contract. The offer usually states the start date. Reporting the recipient's salary and attaching an arbitrary employment statement means that it is not legally unthinkable for an employer to go back on his word before joining the job, but the process and reason are crucial. 3. Estoppel. Even during any employment week, if the candidate reasonably relies on the employer's promise and incurs quantifiable losses as a result, he may still claim estoppel to seek compensation. He is not guaranteed to win the case, but he poses a real legal risk to employers who go back on their words casually. 4. Compliance obligations triggered by background checks. If the revocation is related to the background credit report, the employer usually must go through the compliance process of formal adverse notice in case of adverse notice waiting period, otherwise it may be illegal. This case doesn't seem to be the case, but many of them didn't reach the disputed objects on the first day, which was often mixed up with the chaotic rhythm of background checks. 3rd, how to divide responsibilities. The chain reaction of email errors and management lacks. The company's conflicting error details show the offer email date contradicts the contract date. No unified notifications, calendar invites, or pre-arrival confirmations were made. On the first day, text messages and calls confirmed vacancies, but no new hires appeared, leading to abrupt dismissals and poor job onboarding experiences. Communication failure risks spillover into civil disputes over improper dismissal and mismanagement. These issues can harm an employer's brand and recruitment reputation long term. Employees should double-check discrepancies between email and contract dates immediately and inquire which document is binding. Evidence tracers will archive email PDF, contract and short message records in a unified way and confirm the registration time, place and contact person the day before the start of construction. Communicate first in advance of emergency. When HR reports absence and dismissal, repeat the facts and negative evidence and ask to cancel improper punishment or issue a correction notice. 4. Self-protection for job seekers. Compare whether the 3 elements, start date, arrival time, registration place, contact person, contract, offer, email, and onboarding portal are consistent. 1. Send a confirmation email with the subject start, state time confirmation. CCHR and direct experience are subject to writing. 2nd, if you want a calendar invitation, let HR or experience send a formal calendar invitation. No invitation is equal to a red flag. 3. Keep all documents, offers, contracts, welfare clauses, background check passing notices, and employment guidelines. In case of sudden dismissal, objectively state the situation through email. Include screenshots of official emails dated the 22nd, ask the company for written explanations, corrections to personnel records, and consult a lawyer regarding compensation feasibility. Background check disputes require compliance-based 2-step notification from companies. Failure in this process may allow employees to defend their rights effectively. 5. Whether this matter can be turned over and whether justice can be obtained depends on whether you have clear written evidence, whether you have suffered quantifiable losses as a result, and whether you leave traces in time. Communicating realistic games, many companies will cancel unreported records after employees make their evidence rational, or postpone employment or reschedule them instead, in order to avoid the risk of estoppel and employer word of mouth. But don't tell myths. Under the framework of arbitrary employment, revocation before joining the job is not naturally illegal. What can really incite the situation is often the three-piece set of evidence plus loss plus process flaws. Finally, have you ever encountered an author having a daily sperm fight or changing his mind on the day he took up his post? Let's talk about who you would like in the comment section. If it's you, how do you put the evidence on the table? Like it, forward it, and pay attention to Xiaolan people. I hope every first day will start with clarity.